Hi, I'm Mike Citrick.
And I'm Sally Hoffmeister.
We're here today with Matt Schwartz, who, beside being a managing partner of Boies Schiller, just stepped into the role of chairman of the firm, succeeding the legendary David Boies, who Vanity Fair in 2003 called possibly the greatest trial lawyer alive. Welcome, Matt.
Thank you for having me.
Your appointment is quite a testament not only to your legal skills and accomplishments, but to your partner's confidence in your vision and leadership abilities. Can you tell our listeners what being chairman of a firm like Boies Schiller means? What are your duties and responsibilities, and a little bit about how the firm is structured?
Sure, happy to. And it certainly is a privilege to have the trust of my partners as the firm moves to the next stage of its development. Boies Schiller is a remarkable firm in a lot of ways. One of the things that I really love about it is the size of it. And that's not to say that we're going to remain at exactly this size forever, but Boies Schiller is now at the size where we are big enough that we can take on the biggest, most significant, most difficult matters in the world for the most interesting clients. And we can take on many of those cases simultaneously. And yet it's small enough that I know all of my partners, and in fact, almost everyone who works at the firm on a personal level. And we get together once a year with all of the lawyers, including our associates and their families. And we spend a long weekend together discussing the firm, discussing business, and just spending time with one another. And that's a really remarkable thing for a firm that operates at our level. In terms of the structure of the firm, I think we're probably not that dissimilar to the way many law firms are structured. We have an executive committee that's comprised of 9 of our partners, some of whom have been here for a very long time, and some of them are of newer vintage, and they serve rotating terms, which I think is very helpful for the organization. We have 3 managing partners, and I've been one of those managing partners for the last 4 years, that are responsible for a lot of the day-to-day management of the firm. The managing partners are, for lack of an analogy, the executive team that, along with our professional staff, other sort of C-suite executives, helps run the business of the firm. And then we have a chairman whose formal responsibilities are actually relatively light, but I think the job entails, and certainly the way it has worked in the past, is that the chairman is responsible for setting agenda, for driving consensus amongst the partnership, and we do almost everything by consensus, and charting the overall strategic direction of the firm in consultation with the approval of the managing partners and the executive committee. I've been part of the executive committee now for a number of years. As I said, I've been a managing partner for 4, and now I'm stepping into this role as chairman. So the management team has been stable for quite a while now. We all work very well together, and we're excited to move forward into this next phase of the firm's development.
Though your firm is only a few decades old, which is very young, as you know, compared to firms like 150-year-old plus Davis Polk, Sidley O'Melveny, you've achieved an international reputation, some would say, because of the litigation prowess of the firm. What do you think has accounted for the firm's success? What do you think your point of differentiation is? And finally, how do you think the firm will look 3 years from now, 10 years from now?
Well, thank you for that. I agree with you entirely. I think that in just a few short years, we're about 27 years old, the firm has really developed a reputation and a brand as one of the best in the world. And I think you're exactly right. It's because of our litigation prowess. In fact, that's all we do. That's a reason for our success, and that's part of what differentiates us. But all we do is dispute work. And that means litigation in courtrooms or in arbitral tribunals, investigations, contentious government and regulatory work, and other kinds of disputes. And we are very good at it. And so I think the reputation that we have and the brand that we have built is Boies Schiller is the go-to firm when you have a really sticky problem. And we take a lot of pleasure in being able to help our clients, as you do too, Mike, navigate your clients through very difficult situations, whether they are the target of a lawsuit or an investigation, or whether they've been victimized or have a claim and are pursuing justice. Having lawyers who understand how to handle disputes all the way through the end, through trial, through the way that the facts and the narrative is going to play in front of a fact finder, whether that is a judge, a jury, a governmental body, Congress, or the media and the public, and sometimes a combination of all of the above. That's what Boies Schiller lawyers are great at. And, as we think about the future of the firm, a lot of what I am trying to do as we make this pivot from a founding generation firm to something that is institutional and durable for the long term is to maintain the quality of that brand, to ensure that we keep that excellence and do that without losing the other things that make the firm very special. A lot of that is just about finding, recruiting, and maintaining the right people. Our law firms at the end of the day are really just about our people and our clients. And so a lot of my time is spent on finding and retaining talent, whether that's people coming directly out of law school or partners coming from other firms or government or companies or elsewhere. We want to find people who are both excellent in the way that Boies Schiller lawyers have to be excellent in their legal skills and also fit in culturally with the law firm. And I think over the next few years, you'll see a continued focus on intelligent, targeted growth as we make this turn.
The legal industry has changed quite a bit over the last 5 years, decade. What kind of changes do you see in the years ahead? And what's your thought on how the firm should be positioned to take advantage and capitalize on those changes?
Well, I think that there are a number of trends, and I think that Boies Schiller is well positioned to capitalize on them. I mean, some of the things, and I'm not saying anything that you haven't heard before, other guests haven't told you, I'm sure, but some of the biggest pressures on the legal industry come from pricing, come from clients who are both increasingly diversified in their legal spend and are looking for subject matter experts as opposed to sending all their work in one place. They are increasingly moving away from the billable hour and looking for alternative fee structures that are advantageous for them for a variety of reasons, whether it's cost certainty or alignment of interests or otherwise. But there's been a lot of movement throughout the industry towards creative economic arrangements that really have law firms acting in partnership with their clients, which is where we want to sit. There's also technological changes. In the 20 years since I've started practicing, litigation has changed quite a bit. When I first started, young associates would spend thousands of hours reviewing physical documents in warehouses somewhere, even without regard really for how they fit into the case, just to sort them to understand if they were potentially relevant or potentially privileged or anything like that. Then over the intervening years, we've seen technological advances that now seem quaint, things like just being able to scan documents. So you could do that document review from your computer with the click of a mouse instead of in a warehouse. Then OCR and search technology, and then increasingly sophisticated search technology. And now, of course, artificial intelligence. I'm not smart enough to tell you how artificial intelligence is going to change legal practice, but I know that it will. And I think both of these things, both the move away from the billable hour and the focus on technology, they work in tandem and they put a premium not on manpower, but on expertise. And that's where Boies Schiller sits. When a client hires Boies Schiller, they're hiring us because our partners have the ability to successfully tell their stories, again, in a courtroom, sort of conference room and the halls of government, or the newspaper, wherever it is. And the ability to be an effective spokesperson, to craft that narrative, again, in conjunction with people like you, is the kind of high-level expertise and counsel that we have always been known for, that we've always been excellent at, and that differentiates us from others in the market. And it allows us to take these industry trends and use them to our advantage rather than be punished by them. So, again, I think the future is looking very bright for firms like Boies Schiller and for us in particular.
Thank you for that, Matt. Like our firm, it's basically storytelling. Obviously it has to be factual in both what you do and what we do and based on the fact, but it's being able to communicate in a way that captures what the message is. And if you can do it in an interesting way that captures the judge's interest, and then when you get to trial, the judge or jury's interest, and with us, the court of public opinion, the same thing, that gives you a big advantage. Do you agree?
I do. That sort of experience and expertise and wisdom and counsel is very hard to replace.
Well, again, congratulations on your new role at the firm. As you know, this series of podcasts is examining the intersection of the court of law and the court of public opinion. So before we get into that, Matt, can you tell us a little bit about your background? Where did you grow up? What was your childhood like? What did your father and mother do?
Sure. So I was born in Boston, but grew up mostly outside of New York. My father was originally a physicist, but pivoted to medicine. So I was born in Boston because he was completing his training at Mass General. My mother was a high school English teacher and then later on an early childhood teacher. I went to public schools in Westchester outside of New York City and then went 20 minutes south to Columbia for college and liked it and stayed there for law school. And professionally, I started my career working briefly at a major law firm here in New York City, an international law firm. And there arose a sort of sudden opportunity to go work for a federal judge downtown, a district judge in the Southern District of New York, who had a particular case that was so massive that she got funding for an extra law clerk that was hired off cycle. And so I went to go work for Judge Shira Shinlin in the Southern District of New York, and then for a judge, Thomas Meskel in the Second Circuit, which caused me to move to Connecticut for a year. That was the longest I've been out of New York since my very early childhood. And working for the courts convinced me that I wanted to be a prosecutor and work in government. So I became an assistant U.S. attorney for the Southern District of New York in 2005. I was originally primarily a civil lawyer for the government, including through the financial crisis, where I had the privilege of being involved in some very high-profile, notable cases. It was the first time, really, even though AUSAs were barred from speaking to the media, that there was an interface between what I was doing and the public. And in fact, when I represented the Treasury Department and the auto task force in the bankruptcy of General Motors and the other car companies, I had the odd experience of seeing the President of the United States talking about my case on television. He did it much better than I could have. Through the financial crisis, a lot of companies that were tainted by fraud had that revealed. And so there tended to be a lot of overlap between the work that I was doing on the civil side and bankruptcies and the criminal cases that my colleagues were prosecuting, the biggest of which was when Bernie Madoff's firm fell into bankruptcy following his arrest. And with that case, I sort of completed a transition that I had been working on for a year or two and really moved over to the prosecution side, where I became financial crimes prosecutor for the next several years, dealing with cases like the investigation of Bernie Madoff and the people who worked with him and other cases that you might have heard of, like the London Whale, if you recall that one, and the deferred prosecution of JP Morgan and Commerzbank, the German lender, on anti-money laundering charges. And in 2015, I left the government and I joined Boies Schiller, been here ever since. Complete litigation practice, including white-collar defense, government investigations, congressional investigations, complex commercial disputes, and crisis management.
On the Madoff case, did you have any direct interaction with the media?
Well, again, the policy of the U.S. Attorney's Office, and I think the Department of Justice more broadly, is that line prosecutors don't deal with the media. That's dealt with by public information offices or senior figures. So I certainly was never on record with members of the media. There were a number of members of the media that were covering the case very closely, and I got to know them through their coverage. And ultimately, we had a trial that lasted for literally 6 months of 5 people that worked for Bernie Madoff. And some of the media were there in attendance every single day. And so, without telling them anything that was not in the public record, we would talk to them and help them explain what they had heard through the day.
Yeah, when we did the Food Lion case, which is a case study in the Columbia Graduate School of Journalism, we would do the same thing. We would explain the case, and we would actually do summaries. So journalists who didn't show up at the trial would get their information about the trial from us, knowing, of course, we're advocates, but we wouldn't change the facts.
Well, I just was curious, did you play a role in the strategy during that Madoff case?
I don't know that there was much of a media strategy other than to identify the people that were responsible for the wrongdoing, to prosecute them, and to prove that in court. I think the people involved in that case, the defendants, whether they went to trial or pled guilty, and the other people who got caught up in that investigation, certainly did have their own stories, and they went out of their way to tell their own stories. I mean, Bernie Madoff had his own story, and his family had their story.
Mm-hmm.
The people who worked for him had a story about the extent to which they had been lied to by Bernie Madoff, and to be sure, he lied to them a lot. So, even where there's no doubt that a massive crime has been committed, there's still more to the story, particularly when you're talking about a fraud. The question often is about, what did people really know?
Mm-hmm. The nuance, right?
Right. Just think about that case. There were people who for 40 years, every day they showed up and they processed paper in support of totally fake trades to help someone else commit a fraud. Some of them knew what they were doing. Some of them had no idea what they were doing. And figuring that out was our job as investigators and prosecutors. But communicating their story was certainly part of the defense strategy.
Matt, I understand judges will instruct the jury not to read about a case, not to look on social media. But how do you make sure that can't happen? Or can you? Because certainly the Madoff case is a perfect example, got enormous media coverage.
I think the most important thing is to understand when you pick a jury that it's unlikely that you're going to have a juror who's not been exposed to some aspect of the story. And the question isn't to find someone who is untouched. It's to find someone who, despite what they've heard, can still be impartial and listen to what happens in the courtroom, can listen to the facts, can listen to the evidence, and can listen to the judge's instructions, and to the greatest extent possible, not bring any of that external noise into the courtroom. I mean, if you were looking for a person who hadn't heard anything, you would end up with a terrible jury, right? That's not the jury that anyone wants, prosecution or defense. You don't want someone who is so ignorant that they don't know anything about one of the things that has been on the front page of the newspaper for the past several years, whether that's the fraud of the century or whether that's the prosecution of a former president. You want people who, notwithstanding their exposure to some media, can be impartial and can follow the instructions and just rely on what's happened in the courtroom.
But I'm not talking about before the trial. I'm saying during the trial itself, right? And they go on their Facebook page. There's no way that you can know if they're looking at the New York Times or seeing what's on X. And I assume there's no way you can prevent that.
Well, there's no way to prevent that short of sequestering the jury, which is not attractive. You could, I guess, monitor jurors' social media to see if there was some reference to something that was happening. But short of that, there's no way to police what people are looking at. That's partly why it's important that even during a trial, the coverage remain fair, not because you're trying to influence jurors. You're not. You're hoping that they don't pay attention to the media, but to ensure that what is out there is fair and accurate.
Which is, of course, what we do, right? Now, let's transition to private practice. Do you find there are similarities and differences? Why don't you contrast them for us?
I think it's quite different. Obviously, there are a lot of aspects that are totally different. I'm not sure they're of paramount interest to your listeners, the entire business of law is not something that a prosecutor has to worry about. You don't have to worry about keeping your time or doing your bills or where your clients are going to come from or things like that. But in terms of the actual practice, I think people often refer to leaving government and going to private practice as going to the other side. And it is very rarely that. The job of a prosecutor is exceedingly simple. Not easy by any stretch, but simple, straightforward. They always told us, you have one job and it's to do justice. That's maybe a little bit too simple, but the job is to figure out if someone has done something wrong, and if it's appropriate, bring charges, prosecute them, and prove those facts in a court of law. And that's kind of it. As a lawyer in private practice, you are representing the interests of your client, and the interests of your client are not simply the flip side of the government's interests. First of all, a private client, whether it's an individual or a corporation, is going to have all sorts of important interests that have nothing to do with the legal dispute they're in, but which may be affected by the legal dispute. That can be business interests, it can be reputational interests, it can be dealing with counterparties, it can be financial interests. And then the way that they deal with their legal problems is also much more multifaceted than simply defending against potential or actual charges.
I would like to know a little bit more about in private practice. What is your practice at the firm in terms of media? How do you handle it? Do you handle it internally? Do you handle it lawyer by lawyer, their own cases? Do you hire firms like ours that are specializing in crisis? I suppose it depends on the case, I'm sure, but can you give us a sense of how you approach it?
Sure. So first and foremost, it comes from the client. And most of our clients here at Boies Schiller are sophisticated and have some experience with dealing with the media. Sometimes they have their own public relations or investor relations functions. And so you'll deal with in-house professionals who do this for a living, but typically not in a crisis communications model. Sometimes you're dealing with individuals who may be very sophisticated, but not super savvy about the media, and they require more advice and guidance. But it really, whatever it is, it comes from the client. So sometimes they'll have in-house professionals. Sometimes we as counsel will provide the public relations advice or strategy. Sometimes we'll work with outside crisis communications specialists, and we've certainly worked with Mike and his firm before.
Tell me, if you had to pick one case as that which you're most proud of in terms of the results you achieved or result you achieved for a client, what would that be? I know that's hard. I know it has hundreds or if not thousands.
Well, I mean, it's actually impossible for me to talk about as a result of my practice. And my practice is largely representing individuals and companies that are caught up in government investigations of some sort, either criminal or regulatory. So the biggest successes I have are the cases that never become public, or at least that the government investigation aspect of it never becomes public.
Yeah, we understand that because, quite frankly, one of our greatest successes is when the stories never see the light of day.
Exactly. And sometimes there'll be a story about something that has happened that triggers an investigation or that reflects the facts that are being investigated. But there's a big difference between reporting about, for example, a loss at a company and a report that the government is investigating that as a potential securities fraud. And that's quite different from that company or individuals associated with it actually being charged with a crime. So the greatest successes are the ones where our involvement and investigation or potential charges never get reported.
We had the case where Patty Dunn, the chair of HP, was indicted for spying on our board, pretexting. Quite frankly, she nor I had ever heard the term before. And the first thing we did was to sit down with the reporters covering it on an off-the-record basis and tell them what they got wrong. And we said, we're not looking for corrections. We just want you to get this right, and here are the facts. She ended up on A big story in the New Yorker and big story in the Wall Street Journal. I put her on 60 Minutes, and her attorney was Jim Brosnahan of Morrison and Forster, who's now retired. And Jim turned to me during the broadcasts and said, "How do I let you talk me into these things, Mike?" But it was a major contributor in terms of getting justice, and all charges dropped for Patty. I remember Leslie Stahl said to her, "This is so painful. How can you stand something like this?" And I still get the chills when I talk about it. And Patty said, "When you have stage 4 ovarian cancer and just months to live, it puts things in perspective." And I remember I was watching this with an editor of Forbes when it broadcast, and I saw tears coming down his cheek, and I thought to myself, we won. And we did. So that's what I'm talking about, where you have something that's really an injustice, right? And you've been able to show this as an injustice and to get justice for your clients.
One of the clients that I've been representing for a number of years now is a foreign bank. And this bank, it was revealed at the start of the financial crisis, had been defrauded by its then chairman by 6 or 7 billion with a B dollars. He had run this very elaborate, but not that uncommon scheme where it caused the bank to underwrite loans to related companies and then issued new loans to repay the old ones in a sort of Ponzi-like fashion and took billions of dollars out of the bank. And when the bank hired me, which was 6 or 7 years after the fraud had been discovered, they had been trying very hard to recover that money, to figure out where it went, but also to tell their story in a way that was clear that the bank itself was not accountable for what had happened. They had obtained default judgments in foreign countries. They had obtained a little bit of assets, but they had not ever had real success either recovering money or, more importantly, in getting the truth out there. And when they hired us, they said, one of the things that's very important is, unless we can get our money back, we want to have a trial in a New York courtroom where the people who were involved in this fraud can be held to account, where the story can be told, and where we can get a judgment that the world will understand is a legitimate judgment that reflects that we were victimized here, victimized to the tune of billions of dollars. And we spent the next several years as we were pursuing that case on behalf of the bank, conducting a factual investigation, both independently and through the formal discovery process, interviewing and taking the testimony of witnesses, gathering documents, with an eye towards really telling their story. It was really interesting because it put me back in my old prosecutor shoes, where I was essentially investigating a fraud and money laundering scheme and then preparing to put evidence of that, real evidence beyond a reasonable doubt, before a jury. And that's exactly what we did. Not surprisingly, the people involved in the fraud had no interest in admitting liability or giving the money back. And so we held a trial over a period of several weeks where we put on evidence from each of the wrongdoers whom we had tracked down all over the world. We had taken testimony in Switzerland. We had taken testimony in France. We had gotten evidence from the Emirates. We had gotten evidence from the former Soviet Union. We had gotten evidence from Cyprus and the Isle of Man and all sorts of jurisdictions. And then we told the story to a New York jury, including those people who, of course, refused to come to New York and refused to testify live in a New York courtroom because they were afraid of the consequences. And at the same time, our client, which had a sophisticated public relations function, was on a daily basis using the information that was coming out in open court in furtherance of their other goals of assuring the market, assuring investors, assuring counterparties, assuring potential depositors that they were real victims here and that they were doing everything within their power to hold people accountable and to recover the money. We ultimately got a complete judgment for our clients, and they got the verdict from a New York jury, and then ultimately findings of fact from a federal judge in New York. that they wanted in order to vindicate their story.
That's great. Talk to me about two things that I want to raise. One is we feel that it's important, if you care about the court of public opinion, to write a lawsuit in a way that tells the story. And likewise, if you're a defendant, to not just say deny, deny, deny if you have all these horrible allegations against you, but deny and show that it's not true. Because if you settle, what we found, if you have a lawsuit that makes accusations of fraud or Me Too or whatever it is, and you just say deny or you settle before you file your answer, the allegations are out there forever. And it looks like you bought your way out of that. How do you feel about that? And what's your practice?
I think any lawyer and any client in a material dispute like that would be really ill-served not to understand that media coverage is now a critical part of almost every high-stakes lawsuit. And so if you are pursuing a claim, if you are a plaintiff or if you have counterclaims, then ensuring that your story gets out there is important, both to frame the narrative and in order to ensure that the truth is out there for the inevitable counterpunch that you're going to get from the defense. When I started practicing 20 years ago at that large firm where we mostly represented defendants, the strategy was always say nothing. We never want to be in the media, which is often true, but increasingly unavoidable. The less said, the better. And to your point, while that is sometimes still the correct strategy, if you say nothing, the allegations against you live forever. I mean, we see this in my practice now. Even if someone is tried and acquitted and a jury finds them to be not guilty, the stories of their arrest and charges, sometimes even the press release from the government, lives on the internet forever. And the fact of those allegations living on can be incredibly damaging. Every future employer or counterparty or whatever it is going to dig that up. And so if the other side of the story is not at least presented to contextualize the allegations, then it puts a client at a real disadvantage.
And of course, we have the same feeling. Most of the senior partners of the firm are ex-journalists like Sally, and so they understand this from the other side of the table. We have the same thing. I said in my last book that I think in most instances, no comment is PR malpractice. There are times you have to comment, but there have been situations where a reporter will say, look, I'm going to give you some questions. And they say, well, we're not even going to look at it. And I said, well, get the questions, find out what they are. There isn't a judge saying you have to order this question. You can answer one or you can answer all of them. And our experience is, in most instances, they answer most of them. Sally, I mean, from a journalist standpoint, what's your feeling on an ex-journalist from somebody not commenting?
Well, you always feel that they're guilty, of course, and they have something to hide if they don't come to the table, right? And, we always try to push back and use it as an opportunity to put facts on the table. In two instances recently, in fact, when we did so, the reporter stopped reporting. I think we slammed them so hard with the answers that their whole premise fell apart. Our findings are just what you say. In this day and age, you don't even have to only worry about traditional media. You have social media and all the commentary by uninformed, informed, and everything in between. So there's so many different narratives out there. You kind of have to work twice as hard to make sure that your side of the story gets told.
But let's talk about how you prepare a witness to testify. And quite frankly, we prepare our clients the way a lawyer prepares their clients to testify. We're testifying in the court of public opinion for the media, and we will often ask questions which are much more direct and much harder because the reporter will judge not only by what you say, but by how you say it. How do you prepare people for this, and how do you balance the legal testimony and how it's going to be perceived by the media, especially the public, especially high-profile cases that will get a lot of media attention?
Of course, it depends on what forum they're testifying in and what kind of matter and what the stakes are. But in general, I think preparing a witness to testify has a few different parts to it. A lot of it is simply making sure that they are comfortable telling their story, that they're thoughtful about the way that they do it, that they choose their words carefully but are natural, and that they're familiar with the other facts that are in play so that they don't either inadvertently or otherwise say something that's subject to being contradicted. And so that means you spend a lot of time, for example, if someone is going to testify at trial, right? Which means I'm going to examine them on direct examination. They'll have an opportunity to tell their story, and then they'll be subject to cross-examination. So a little bit different than, for example, testifying as a third-party witness or in front of Congress. So in that context, I want to spend a lot of time just hearing them tell their story. They need to be comfortable doing it. I need to know the way that they tell their story so that if they tell it a little bit differently on the day, I know what follow-up questions to ask to elicit the information that we have decided is important for the jury. I'm going to spend a lot of time reviewing with them anything that they've said previously so that they don't contradict themselves, whether that is sworn testimony or whether that is things that they've said publicly in news reports on the record. So if you have someone who is a public figure who is testifying about something that they have talked about before, it's critically important to understand that record and make sure that they are familiar with it so that they stay consistent with themselves, or if they've genuinely changed position, that they do that thoughtfully, knowingly, and are prepared to explain that. We also want to understand the other facts that are out there, whether that's what other people have to say, whether that is documentary evidence, whether that's evidence of some other sort, so that that person's story is consistent with all of the other evidence, so they're not subject to being contradicted or impeached by other evidence. And then we spend a lot of time practicing the sorts of questions that they may get from other questioners. And we'll practice different ways because there's a mode of cross-examination that is really hard-hitting, and you try and make someone uncomfortable and you confront them directly. And then there's a mode of cross-examination that is much more friendly, at least it appears much more friendly. And you try and get a lot of agreement and you try and get concessions that way. You try and trip people up that way. And they have to be prepared either way. I mean, in a lot of ways, the aggressive cross-examination is the easier one to prepare for because you sort of know you're being attacked at all moments. And as long as you keep your composure, then you'll probably do okay. The cross-examination that appears more friendly, that appears softer, can often be the far trickier one because you have to really listen carefully to every single question. You have to listen to not just the end of the question, but the beginning of it and all the assumptions that are built into it. Because at the end of the day, all you're left with, again, the example of a court of law, is a transcript that's going to have, stripped of all other context, answer. And if you're not thinking about the way it's going to look on paper at the end of the day, about all the lead up to the question, about the particular grammar used, where sometimes a yes sounds like a no and a no sounds like a yes, right? Isn't it the case that? Wouldn't you agree that? Would you not agree with me that? And you can phrase questions in a lot of different ways so that people even get crossed up about what's a yes and what's a no. So preparing a witness for all of those things so that their answers are precise but not evasive, so that they look like truth tellers because they are truth tellers, is time consuming and difficult, and one of the most important things that we do, because ultimately the case comes down to the evidence, and the most important evidence to a fact finder is usually what the most important witnesses have to say. In prosecutions and criminal cases, very often the chief cooperator, the person who was a co-conspirator of the defendant, according to the government, and has become the government's main witness, everything comes down to whether a jury believes that person. And of course, if a client ever chooses to testify, then it really comes down to, does a jury believe what this person has to say?
I want to come back to the impact of the media and the impact of public opinion. But before we do that, tell me about your new job, or what your new job is going to be. And what does it entail? How is this going to change your life?
Well, I'm not sure it's a new job as much as an additional job since I'm not giving up my old job.
Yeah, well said.
It's very much in the culture of this firm that the people who are involved in management remain full-time trial lawyers first. And David Boies has been setting that example for the last 27 years. And our other founding partners, Jonathan Schiller and Don Flexner, while he was with us, the same thing. And so first and foremost, remain a full-time practicing lawyer. That's important because I love being a trial lawyer. But on top of that now, for the past several years, I've been one of our firm-wide managing partners, which means that along with the two other managing partners, we're responsible for the day-to-day operations of the firm, whether that is IT or HR or finance matters or dealing with our real estate portfolio or helping to recruit new lawyers, whether it's entry-level lawyers from law school or partners from other law firms. We do that. We work as a team. We each have our areas of responsibility, but we also pick up the slack for one another when one of us, for example, is on trial or otherwise tied up with our day jobs. And then starting in January, I will take over from David Boies as the chairman of the law firm, which really means that I'll be responsible for leading the firm, for setting the agenda. We're a partnership, and always our important decisions are made by the partners as a whole or our executive committee in some instances. But providing some direction and helping set the agenda and helping build consensus for the important decisions, I think is a big part of the new role.
So you talked about overseeing the recruiting of lawyers from other firms and also lawyers from law school. And when you talk to them, or if you were to talk to them tomorrow and they were to say, okay, what is the key to my success? How do I succeed? What should I do? What should I not do?
That's a very big question. And I think the answer is quite different if I'm talking to someone who's just coming out of law school versus a partner from another law firm that's been practicing for 20 years. For a lawyer who is coming out of law school or who is relatively junior, the most important thing is to learn the craft, to learn to be a great lawyer. Boies Schiller is a firm of trial lawyers. We all basically do the same thing. And so learning how to effectively represent your client before a fact finder, whether that's a judge or a jury or a government body or an arbitral tribunal, it's really about translating very complicated law and facts into something that an audience can understand, that is accessible but accurate, and is done, of course, within the sort of technical confines of the law. And so, I tell those people to be successful, watch and listen very closely, go to court as much as possible, become a court watcher, go see people in action, understand that there's not a right way to do anything. There's many effective ways to be a great trial lawyer. You said that someone said David Boies was the greatest trial lawyer of,
I think it was Vanity Fair.
There you go. And he may well be that, but he's got his own way of doing things. And you can be a great trial lawyer without being David Boies or trying to emulate him, just like any other great trial lawyer. Some people are very dynamic and they make it about themselves. That can be very effective. And sometimes people are very sort of just the facts, and that can be very effective. And some people are variable depending on the circumstances. But the most important thing is to find a style that is comfortable and effective for you.
That's what we do in our firm. I'll go in and talk to Sally about something, and she'll say, "You're really not going to do that, are you?"
Or I say, "I don't think that's a good idea, Mike."
But you want the best thinking, so I'll rethink it. Yeah, you're probably right. But sometimes I say, maybe I will.
It's a brainstorming process.
So we have had situations where the media pressure has been so great that client is settled in as little as 2 days afterwards. The stock dropped, 2 instances I can think of off the top of my head. But have you seen where the media pressure can change a client's mind?
Yes. So here's what I'll say about that. I've certainly seen cases where things that were happening publicly And sometimes it's driven by media, but it's not necessarily the media pressure. It's that stories come out and then investors start asking questions, counterparties start asking questions, and it creates intense pressure to resolve matters or change course very quickly. That definitely happens. I will also say clients, especially clients who have a claim, plaintiff's side clients, think that happens a lot more than it does. I can't tell you how often a client comes to me and they've got a very good claim and they say, here's the strategy. We're going to send them a letter and tell them that if they don't settle for a ton of money, we're going to sue them and it's going to be in the newspaper and they're going to pay us a ton of money because they're not going to want that. I say, okay, well, maybe, but probably not. Usually, at least before they pay you a lot of money, they need to understand that the claims have merit. They have to understand that you're serious. So sometimes that happens.
If I could get this result on a regular basis, my fee structure would be very different than it is.
So sometimes that happens, but it is rare. It's rare because I think even when there is tremendous public pressure from stuff that comes out in media reports, companies or individuals don't realize that threat when it's hypothetical. They tend to discount it. And so they have to experience some of that pressure in order to have their behavior change. The problem is very often the first salvo is the most painful, and then there's no ammunition left. And at that point, why not dig in and fight and defend? To your point, we have to put the counter narrative out there. We have to defang this because otherwise, if I just settle, then that's the story that's going to be out there and that I capitulated very, very quickly. And so it's got to be calibrated very carefully in order to be effective.
Yeah, when we ran the campaign for Roy Disney against Michael Eisner, the Withhold campaign, we had to have a series of actions over a series of months. But on the patent stuff, I was kind of surprised myself. We filed the lawsuit 2 days later. This was Dolby against BlackBerry. It was called RIM then, but BlackBerry had not signed a license for the sound compression technology Dolby had. And so the general counsel called me up and he said, Sandy Robertson, who's one of the people who's credited with creating Silicon Valley, is on my board, and BlackBerry won't sign this license. And we can't let this continue to go on. Sandy said, you can make them settle. I said, I love Sandy, but what's the case? And he told me, it was over the sound compression technology. And I said, how much are you seeking? And he told me, and I said, it's a little bit like Mike Myers in the Austin Powers movie when he was Dr. Evil. And he said, I'm going to ask for $1 million. And everybody was laughing. I said, but what if we seek to enjoin the import of BlackBerry into the United States and Germany? We were filing in both countries, and they won't be able to stand the pressure. BlackBerry was just starting to come under pressure then. So the other outside lawyer was on the phone, and the general counsel had gotten off, and he says, Andy won't buy that. And Andy got on, and he said, what won't I buy? And he loved the idea. So we made sure that the lawsuit was more media friendly. We broke it exclusively in the Wall Street Journal and on CNBC at the same time. And CNBC, and I said, don't just say the damages to be determined at trial, because nobody will take it seriously with the damages they had. Not that it isn't a lot of money, but in those schemes it isn't. And we did that, and then we gave it to Bloomberg, and we got 700 stories within 2 days. And BlackBerry called and said, stop the media, the stock cratered. We'll not only pay the legal fees, we'll pay the licensing fees, we'll pay the backlights, we'll even pay your PR fees. So again, if I could do that every day, it'd be a different story.
Mike calls it putting the opposition under the wheel of pain.
Every time I'm deposed, I'm asked about the wheel of pain because it's in both my books.
It's a great phrase. I would like to ask you about your profile with the media. David Boies had quite a high profile with media and had some relationships in the media. I think everyone is aware. What's your approach with the media? Do you have relationships? Do you cultivate relationships? Do you care to have any relationships with reporters and editors?
Well, I think that there's a group of reporters who tend to cover the courts and tend to cover financial crimes. And to varying degrees, I think it's useful to maintain relationships with them because the information flows both ways. And it's incredibly helpful to my clients to have any insight into what is going on in a non-public investigation. And the reporters, at least on this beat, are, in my experience, very good. And they learn a lot of things about what is going on that are not yet public. And so if by maintaining a relationship with them, I can learn information that allows me to serve my clients better, I absolutely want to do that. Not for sake of my personal profile, but for sake of servicing my clients.
The relationship does benefit your clients, and it's a matter of just being courteous. There are some lawyers who just aren't courteous. And even if you return what I tell my friends who are lawyers, my clients, even if you return the call and say, look, I'm really sorry, but I can't comment on this, it's better than just blowing them off, because there are PR people who will yell at lawyers, yell at the journalists, and Sally knows. And they say, oh, it won't affect the coverage. And I'm quoting my last book, but it's out of print, so I'm not trying to promote the book. But, I say, look, they're human beings. And when you yell at them and you treat them with disrespect, if you give me a set of facts and I can give you 4 stories from the most negative to the most positive and not change a single fact. And so where they decide to draw those lines is just a matter of common courtesy.
It's important also to build a track record of being credible with reporters. They know when you're selling them a line.
They do. And I always tell clients, if there's a video, a text, an email, they will find it and it will undermine your credibility forever.
That just reminded me, because one thing I wanted to ask you about social media. Sally mentioned email. When you're preparing, I'm assuming that when you get a client, you have either your research people or your associates not only check to see what's in legacy media, but what's on Twitter. And did they do anything when they were in college? I mean, is there anything embarrassing? And is that part of your search?
Sometimes. I mean, again, it depends on the nature of the representation. I don't always have to do that kind of excavation, but certainly if a person's personal credibility is going to become an issue, then understanding that there is not something out there that's going to come back and bite us is important. I certainly do that kind of research when I'm going to be attacking someone's credibility, whether it's cross-examination or something else. That is a treasure trove, because even when people have not posted things that are terrible in their own right, they often will have stuff there that you can use to contradict and impeach them in a variety of ways.
Well, likewise, your own clients, you want to make sure they don't have anything out there that can be used against them, right? Matt, if you're representing a client and he has a very damaging lawsuit filed against him or her, your client says the allegations are not true, it's picked up in the New York Times, and from the New York Times, papers across the country, or if it's an internationally known person across the world, pick this up. And let's assume it's picked up worldwide. And of course, the client is very upset about this, because not only is he being sued, but now it's every place you look, social media, legacy media. And he says this is completely false.
So the tension in that situation is always this. There's a strong desire to put a forceful denial into the public record as soon as possible, preferably one that is not just a denial, but that has some meat to it.
Because it has to have substance to matter.
Right. If you just say, I didn't do it, or he or she didn't do it, what's a reader going to do with that? I mean, okay, they know that you deny the allegation, but they don't know what your side of the story is. On the other hand, putting a forceful, factual denial into the public record before you actually know the facts can be very dangerous. And, I think it's why often the careful lawyer, who's not always in the right, but the careful lawyer will say, well, let's wait. Let's understand what all the facts are. Let's understand what the record is before we speak publicly, because we don't want to get caught saying something that's not going to hold up 100%. You can do that. But if you do that, sometimes you let a lot of opportunities go by. Public opinion can harden. Things will be out there without any response or rebuttal that are going to live out there forever, as you say. And so figuring out whether it is possible to say something forcefully, quickly, and credibly is really what the game is at the very beginning. And it's why it is important as a lawyer to get right on top of these allegations when they occur, and ideally before they are made publicly. It's unusual in my experience that the very first shot that is fired by the other side is really noisy in public. The problem is people, companies, clients often feel when the first shot is more subtle that they can just ignore it, that it'll go away or that they can manage it. And that's a missed opportunity. At the first sign that something may be a problem, it's important to understand the scope of that problem, to understand the real facts, so that if and when it gets very messy, you're prepared to comment publicly in a way that is forceful, credible, and robust.
But let's assume they do have detail in this. I mean, I know you can give a response and say, look, the filing is replete with inaccuracies. We'll respond at the appropriate time or something to that effect. A little better worded than I just did. But you can't just not comment. And the client, and I'm saying the client is losing their mind because it's so damaging. One of the things we do is we'll go to the reporter, and if we have to, we go to the editor and say, look, we just got blindsided by this. We need time to prepare this. You gave front page coverage to the allegations. Fairness would dictate that when we file, assuming it's equally newsworthy, we get the same kind of treatment. And if we have to, we then will go to the editor. And if otherwise, we would say to you, Matt, we need a letter to the general counsel. I'm just using the New York Times, the New York, whoever it's in, New York Times, Wall Street Journal, in terms of fairness, using not threatening to sue, but asking the general counsel from a fairness standpoint, because they're kind of the police of the media. And so is that something that you would do if the situation merited it?
I think if the response is, as you say, sufficiently newsworthy that it should get the same coverage, we would fight for it to get the same coverage, assuming that's what the client wanted. In general, I think reporters want to have stuff to publish. I think that's increasingly true as more publications are moving more content online and there aren't restrictions on what's posted. And so if you have something that is newsworthy, if you're really telling a new story, if you're putting new information into a story that already has a lot of public opinion, I haven't had a lot of trouble getting coverage for that. But if you do, then yeah, you appeal to the journalistic instincts of the reporters and the sense of fairness of the lawyers.
And if you have to appeal it, you appeal it. Because I've said, look, I'm going to appeal your decision to your editor. And every so often I'll have a reporter say, are you threatening me? I said, would you rather me go behind your back? No, I'm not threatening you. And I try to work, most of the time we work with the reporters. We don't have to go over their head. And what they will say to you is, look, I have to see what you have before I can commit. And so that's fair enough. But if they then say, I'm going to give it 3 paragraphs and they gave front page coverage to the other, at that point, if we feel, the lawyers and we feel it merits it, we'll appeal it.
Yeah, and I don't think there's anything inappropriate or threatening or insulting about that. That's just good process. The identical thing happens when you're dealing with prosecutors. Very often, the so-called line prosecutors who are investigating a case, they may form a certain view because for any of a million reasons. It may be that they're just living with something for too long. It may be that they don't have the sort of wide angle view that the supervisors do or that the editors do. And so you avail yourself of the process that exists, which is to speak to the powers that be, whether that's editors at a publication or supervisors in a prosecutor's office. And yeah, you're transparent about that to the people on the ground because number one, you're going to have to likely live with them for a long time.
That's right.
And you don't want to insult them. And you're not trying to go around them. You're not impugning them. It's not that they've done anything wrong. It's that you want a different perspective from people who have a different job within the same organization.
Sure. Yeah, we're not adversarial in those situations. Matt, thank you very much. And we appreciate your doing this.
Well, perfect. Thank you both for having me.
Thanks. You've been listening to The Intersection of the Court of Law and the Court of Public Opinion with Mike Citrick and Sally Hoffmeister. This is a production of Citrick & Company. To send your questions, hear clips from the show, and learn more about us, follow Citrick & Company on LinkedIn and visit our website, theintersectionpodcast.com. That's theintersectionpodcast.com. podcast.com. Be sure to follow us on your favorite podcast streaming platform. And if you like what you hear, please leave us a comment or review. Once again, thank you for listening.